Good morning and good evening. Good morning in Botswana, in the Netherlands, and good evening in Australia. My name is Aurélien Lorange, and together with my colleagues from the Corax Foundation, we'll be having this match, the third match in the group phase. So I give the floor to my colleague, Ms. Urbanova.
Thank you. Thank you very much. And once again, welcome everyone. Good evening to Australia and good morning to Botswana. Welcome to the students. It is a pleasure to open the round 3 debate for the two teams. This team is tied to cybersecurity and development in technology and the strides that international law or the regional laws have made. Specifically, the topic for debate of today is that over-reliance on international cyber treaties may hinder swift responses to rapidly evolving cyber threats. So the two teams have prepared in advance, 7 days in advance, for both sides of the argument. We'll of course find out soon which position will be defended by which team. But before we do that, it is the final introductions of the group phase for the two teams. But nevertheless, just as exciting as the first day. So perhaps starting with the University of Botswana, Ms. Njanda.
Good morning, and my name is Ruby Njonde, and I'm a third-year law student at the University of Botswana, and it's a pleasure to be here.
Thank you, and welcome again. Now passing the floor to Monash University, Mr. Tan.
Good morning, good evening, everyone. My name is Michael. I am a final year Law and Commerce student at Monash University. Very happy to be here.
Welcome again from University of Botswana, joining us, Mr. Setilo.
Good day, everybody. My name is Neo Ruth Sitilo, and I am a fourth year at the University of Botswana studying law, and it is a pleasure to meet you all.
Thank you, and welcome again from Monash University, Mr. Law.
Hi, my name is Joel. I am currently a fourth year Bachelor of Laws and Bachelor of Arts student at Monash.
Thank you, and welcome again. I would also like to extend our gratitude to the three judges that will be overseeing your match, that will be sharing the time and the experience with you through the evaluation forms. And thus, without further ado, please just give me a confirmation when you can see the screen, and we'll find out in a second which position will be with which side, which team.
Yes.
Thank you. So as always, there are 4 possibilities. All right, so for today's debate in the round 3 of the Hague Inter-University Law Debate Tournament, the position against the statement will be defended by Monash University debating team. To confirm, the over-reliance on international cyber treaties may hinder swift responses to rapidly evolving cyber threats will be argued by the team of University of Botswana, whereas the against position, such as the over-reliance that may not or does not hinder, will be defended by Monash University debating team. You now have 5 minutes to finalize your preparation. Afterwards, the team in favor will start. Thank you very much. So the final time for preparation is now over. We will now proceed to debate, starting with the team in favor, debating team of University of Botswana. You have 4 minutes for your opening statement, whenever you're ready.
Greetings to the House at large and the judges and the panel. We're going to start with side for this motion, and we are saying that over-reliance on international cyber treaties may hinder swift responses to rapidly evolving cyber threats. Now, firstly, as of 2018, 89% of households have had more access to internet, and also this means that the level of cybercrime and cyber attacks has also increased. And so we need to be able to effectively combat and strategize against these cyber attacks in order to be able to ensure a safe digital space. By cyber insecurity and cyber attacks, this takes the form of cyber warfare, espionage, crime, attacks, and the exploitation of cyber systems. It is a worldwide global problem because all aspects of cyber insecurity have a transnational component affecting users in Cuba, Germany, Australia, and Botswana alike. So we believe that this stems from the fact that cyber systems have been designed to facilitate access and utilization rather than security. And these cyber attacks are damaging for cyber systems which support infrastructure like power grids, air traffic control, financial systems, and these offensive maneuvers use the internet and cyber systems and allow individuals to commit fraud, steal, recruit and train terrorists, violate copyright laws, convey hate speech, and sell child pornography. So we believe that it's very important to be able to effectively tackle and combat cybersecurity issues and cyber insecurity on a global scale as fast and as speedily as possible. The best way to do this is to be able to rely also on national governments. That is what we say as we are for this motion, national governments and private organizations that can be able to better come up with countermeasures that are both effective and fast in tackling these cyber attacks and these cyber insecurity issues that arise in the digital space that we see today. So we believe that an over-reliance on international cyber treaties may hinder swift responses to rapidly evolving cyber threats. Firstly, we see that there's a lot of cyber treaties that have already been put into place. For example, the Budapest Convention on Cybercrime in 2001, which has a lot of conventions that can enable domestic governments to be able to enact laws that prevent and provide countermeasures against cybercrime and cyber attacks. However, we believe that this also creates a lot of loopholes and a lot of openness because they are less specific on the types of countermeasures that can be implemented by these domestic governments. Mostly, the Budapest Convention mostly talks about how the cyber attacks should be made criminalized by these domestic governments, but yet fails to really provide a strategic and specific framework in which these domestic governments can be able to effectively tackle and combat cybercrime and cyber attacks in the digital space. So we believe that these countries, first of all, our first argument is that over-reliance fosters over-compliance. Now, what do we mean by this? We mean that these governments seem to rely mostly on these treaties and on international conventions instead of being able to come up with new ways and innovative ways in order to be able to stimulate countermeasures to these cyber attacks, and also to be able to pull and to take advantage of resources from within their countries, from within private organizations, from within domestic private cybersecurity organizations that can be able to come up with innovative ways to be able to combat cyber attacks. So we believe, firstly, it fosters overcompliance. Secondly, over-reliance hinders innovation and speed. Cyber threats, viruses, spyware are constantly evolving. So are the countermeasures that can effectively tackle them. So we believe that we need more than just the Budapest Convention. We need more than just the IEC, which is the International Electronic Commission, or the ISO, International Organization for Standardization. We need more than just these standards. We need these countries to be able to take accountability and to be able to take responsibility for the cyber attacks that are happening within their country. And to be able to do that, they need to be able to overcome red bureaucratic tape or stop relying heavily on international conventions and yet come up with effective and robust systems and frameworks within their countries in order to be able to combat cyber attacks and cybercrime. Thank you.
Thank you very much. So now proceeding with the against position, debate team of Monash University, you have 4 minutes.
Hi. Just checking, am I audible?
Yes, you are.
All right, thank you. Good evening, everyone. Global cybersecurity threats demand a global solution. Our stance is simple. Swift responses can only happen with globally coordinated efforts. We support international cyber treaties like the Budapest Convention, the African Union Convention on Cybersecurity and Data Protection, otherwise known as the Malabo Convention, and a strong UN treaty in the future if it so materializes. I have 3 arguments, and I'll turn to my first argument now. First, why does the nature of these cyber threats justify relying on treaties? The rapidly evolving nature of cyber threats means we need international coordination to fight them. According to a 2008 ITU report, cyberspace is borderless. Cyber attacks can inflict immeasurable damage in different countries in a matter of minutes. There are two types of cybersecurity threats. Cyber-enabled crimes such as terrorism, online child sex exploitation, online scams, hate crimes. And there's cyber-dependent crimes, which can only be committed using technology such as ransomware attacks. For instance, a Russian ransomware group hacked 27 separate Costa Rican ministries and encrypted the data and then demanded a $20 million ransom for decryption. And because this wasn't paid, social services were delayed for months. Turning to the second argument then, how do treaties facilitate quick responses to threats? Firstly, the second additional protocol of the Budapest Convention on Electronic Evidence provides a legal basis for disclosure of information for who registered a website address, direct cooperation with service providers for subscriber data and traffic data across different countries, so on and so forth. Secondly, treaties help to overcome a legislative vacuum which many states face due to a lack of personnel and also because of the expertise and resources required to understand the issues involved in applying international law to cyberspace. For example, prior to the Malabo Convention, 22 African states did not have any data protection laws in place, and many of the states, basically with a domestic data protection framework, were lagging in implementation, resourcing, and necessary reforms and amendments. While the treaties aren't perfect, they provide a tangible framework to advance relevant legislation changes domestically because they provide key provisions that can be easily adopted by state parties. Hence, treaties basically simplify compliance and reduce costs for the uptake of legal reforms. The third argument then is why the predominance and the over-reliance even would work. 3 reasons for this. Firstly, because capacity building programs already exist. The Cybercrime Program Office of the Council of Europe helps countries worldwide build the necessary capacities to implement the Budapest Convention, its protocols, or to follow up to solutions and recommendations. Secondly, solutions to fight cyber threats are currently developed and coordinated through Interpol's Innovation Center in Singapore. They assist member countries in assessing emerging trends, maintaining state-of-the-art facilities, amongst other things. And a treaty that coordinates this body's role in the future would decrease the vulnerability of countries like Costa Rica, which suffered their cyber attacks precisely because of a technological deficit. Treaties are therefore important for inoculating countries against cyber threats. Thirdly, global efforts have been very successful at taking down major cyber threats because of the treaties. Emotet was the world's most dangerous malware offered for hire to cyber criminals as a way to install other types of malware onto victims' computers. In an internationally coordinated effort by Europol and Eurojust, authorities took it down precisely because of the bureaucracy. Hence, we don't think our learned opponents are correct in saying that these treaties have not been effective, and they clearly help with coordinating a swift response. Thank you.
Thank you very much. We have now heard the opening statements from both teams. We'll now proceed to the rebuttals. For the first rebuttal in the position in favor, Bay Team of University of Botswana, you have 2 minutes.
Thank you very much, Madam Speaker. I am Kotasimuloro from the University of Botswana team. Now, our rebuttals are swift and precise to the point. The previous speaker came here and told us that international treaties offer swift response, but we must understand the nature of treaties, that treaties in international law are voluntary documents that require consultation, that further require implementation, ratification, and domestication, Mr. Speaker. Therefore, we refuse to accept the notion that they offer a swift response to this. Instead, the response is more delayed. Now we look at the enforcement aspect of the treaty aspect. The enforcement aspect, like we say, all international law statutes, all international law instruments are voluntary in their nature and lack proper enforcement. What do we mean by they lack proper enforcement? There is no body that can enforce these obligations on states. Should the state choose to violate these obligations of cooperation, should a bigger state choose to place a smaller state in vulnerability, there is no body in place to actually regulate or enforce the treaty placement. Therefore, we believe that by absence of an enforcement agency that places severe penalties on wrongdoers being the states, because in this field we are looking, when we talk about international law scope, we are talking about countries, and in these players we see countries as the main players, or in the international law aspect we see countries as the main players. Therefore, the absence of bodies to hold countries accountable and punish countries then means that whatever body that is placed in a tribunal that a country would be taken to would merely be an inconsequential suggestion. Just as we have seen the failure of treaties in the Genocide Convention, we have seen the failure of treaties in the recent Israel-Hamas case. We've seen that Israel has been condemned, but nothing is changing, nothing has been done, because at the end of the day, all international law instruments are voluntary exercises and lack proper bodies of enforcement. Are we going to attack a country that then comes in to violate these cybersecurity norms? No, we are not. So instead, we feel that the enforcement aspect is therefore unreliable, and therefore the over-reliance will continue to hinder the ability to
Thank you.
curb or
Thank
nip
you. Your time is up.
cybersecurity threat. Thank you.
Thank you for your submission. Your time is up. We will now proceed to hear the first rebuttal in the position against. Monash University debate team, you have 2 minutes.
Hello, can you hear me?
Loud and clear.
Lovely. I thank the affirmative team for their arguments. The core of the affirmative team case is that international cybercrime treaties stymie national governments and innovation from private companies. However, there is nothing in international cyber treaties that prevents private companies or states from acting. In fact, we would argue that it does the opposite, because states have an incentive to join the international community and sign up to new conventions like additional protocols, etc. Importantly, these types of conventions not only oblige states to enforce criminalization policies at the domestic level, but also legislate other measures. This looks like, as Joel stated, effective data protect security measures that actually stimulates the private market when the government would otherwise not have done so. It encourages collaboration with poor developing countries, with countries that are experts on cybersecurity, like the United States, where you can build that knowledge base within the domestic jurisdiction to better protect one's own domestic interests. But additionally, even if this didn't occur, states would be far more powerless if they did not rely on international cybercrime conventions, because they would have to negotiate on a case-by-case basis with individual states in order to acquire evidence, and they would have no guarantee that the state that they were negotiating with would actually have effective data security protections, which elongates the process and allows for discovery to occur on a much larger timescale, therefore preventing that state from swiftly responding to a threat, which is why we need more reliance on cybercrime treaties. The second argument that they made was that international cyber treaties are not prescriptive enough. However, that firstly does not mean that they cannot be more prescriptive in the future, but secondly, they already account for things like countermeasures, either in things like additional protocol 2 of the Budapest Convention, but also in customary international law. We know that countermeasures are valid from the ICJ judgment of Nagimara Skabčekovo. Therefore, it's not going to be a matter of uncertainty for a state when deciding to make a countermeasure. Thank you.
Thank you. We'll now proceed to the second round of rebuttals. The position in favor, University of Botswana, you have 2 minutes.
Ladies and gentlemen, good day. Now, there seems to be a misconception of what exactly our debate topic requires of us. The debate topic is simply telling us that the debate topic in simplicity, rather, is telling us that an excessive dependence on international cyber treaties may make it difficult to quickly and promptly react to expeditiously developing cyber attacks. Now, what we need to understand is that this debate is telling us that we are not contesting the need for international cybersecurity treaties. What we are saying is if we place an over-reliance on these treaties, then we are going to make it difficult to arrest international cybersecurity crimes that are occurring. So the arguments that have been advanced by the leader of opposition, stating that in actual fact they are effective and so forth and so on, are not the contentions of today's debate. Today's debate is contended on the fact that we are alleging that the principles and mechanisms of these treaties are going to make it difficult to swiftly arrest cybersecurity crimes. Now, what I would like to advance here is as follows. Now, that what they are saying is that the rebuttals in today's case is that side opposition is telling us that international cybersecurity treaties are elongating the process because one, they are not binding, so it is not going to be the responsibility of any state to try and enforce the principles contained in it. But what we need to understand is that under international law, what purpose do these treaties serve? What they do is that consent is not required because it is a matter of states having the mental disposition to be bound by treaties, and also for there to be observance over a considerable amount of time in order for us to hold them accountable. So we require that alone in order to be able to hold states accountable for any breach in terms of cybersecurity. This is to say that the whole process of it being a voluntary basis association being null and void. Now, another thing that we need to realize is this. We need to appreciate the fact that the Budapest Convention on Cybersecurity Crime seeks to arrest cybercrime by harmonizing national laws, improving investigative techniques, and increasing cooperation among nations. Now, in so doing, it is going to help us arrest the situation because when we look at international cyber treaties, they are going to allow us to be able to arrest them because we are now looking at the mechanisms that would prevent future attacks from occurring by instilling fear. With that said, I rest our rebuttals.
Thank you very much. We'll now hear the second rebuttal in the against position. Monash University, you have 2 minutes.
Am I audible?
Yes.
There are two major contradictions I want to point out that came out from our opponents. The first contradiction is that the first speaker says that international treaties cause a lot of the slow responses to the cyber threats because the bureaucracy is basically there to counteract all these measures, but unfortunately is a very slow machine. But their second speaker then says all international treaties cannot be enforced because there is no body that can actually enforce any of this. Which is it? Either the treaties come with bureaucracies or they don't. Either they come with some sort of enforcement mechanism or body or they don't. They have to basically resolve this by the end of this debate as a set of contradictions. The second thing then that they did to contradict themselves was the speaker before me says that this debate is not about effectiveness, but their previous speaker the second speaker said that over-reliance on these treaties is bad precisely because of the effectiveness of it, because they have no ability to basically enforce any of the measures. So which is it? What is this debate then about? It seems that the debate actually really is about whether or not these treaties fundamentally are capable of being relied on predominantly, as we've already proven that they can be, right? So they've not actually rebutted the fact that coordination is something that's been proven to be able to happen between countries. In the case of Emotet, the world's most dangerous malware that I talked about earlier, which was something that was able to be stopped and taken down from the inside because of a globally coordinated effort, but both with countries from the global south and the global north working together to basically bring it down. And that's something that was coordinated through Europol and Eurojust. Those things prove that coordination is possible. Consultation isn't also something that takes an enormously long period of time. We would submit that consultation can be swift in the case of, for example, the Malabo Convention, which basically was something that was modeled after the Budapest Convention and was basically adopted by African states. Thank you very much.
Thank you very much. We will now proceed to the conclusions. Starting with position in favor, University of Botswana, you have 2 minutes.
Good day once more. Concluding speech for today's debate. We need to appreciate the simple fact that what we are saying as SAD government is this. The contention of the debate is not on the effectiveness of the mere existence of treaties, which is what SAD opposition was leading us towards. What we are saying as SAD government is that, one, we are saying that as SAD government is that because we are not contending whether or not response is going to be there, because the response that we want is going to be there. However, the effectiveness in terms of time is what we are questioning if we place an over-reliance on international cyber treaties. Now, what we have mentioned is that over-reliance equals to over-compliance. What over-compliance does is that it prevents future perpetration of crimes. And so we propose that we indeed continue to over-rely on cybersecurity treaties, because then we are preventing future perpetrators from coming into the picture and trying to perpetrate these crimes. Another thing that we are saying, when we look at the threshold of circumstantial evidence, we see that in terms of the International Court of Justice, these are things that they take into consideration. We look at the Kofi Channel case, wherein circumstantial evidence was used in order to hold Albania accountable for the UK warships that were struck by the mines that caused fatalities on the people there. So because of that, the mere existence of circumstantial evidence is enough to hold a state accountable. And so when we impose these treaties and the principles that come with international treaties, that includes the admissibility of circumstantial evidence, then we see that it is easier and quicker for us to, one, rapidly arrest the situation by preventing or curbing future cases from occurring, and two, as well as making sure that those who are found responsible are then held accountable for these cybersecurity crimes that they are found to have committed. Now, another thing that we as SAD opposition would like to point out is that the clear debate here, or the clear clash, was between the need for urgency, which is the swift approach in today's debate topic, vis-a-vis the need for certainty, that is the thorough approach. Now, when we look at this, the two cannot contend, because one, we are arresting both situations, because the thorough approach comes in the sense of saying that we will arrest the situation merely off of circumstantial evidence, and we will be avoided by being confronted by these situations because people will be fearful of committing these crimes. With that said, we arrest our arguments as SAD government.
Thank you. Now, to hear the conclusion in the against position, Monash University, you have 2 minutes.
At the end of this debate, the affirmative team had to demonstrate how relying more on cyber treaties now and in the future would slow down a state's response to a cyber threat. Joel explained the reasons why a transnational threat required a transnational response that is already proven effective. However, and importantly, the affirmative team never explained what would happen if states did not over-rely on international cyber treaties. Let me tell you what would happen if they did. If states relied less on international cyber treaties, that means that they are less likely to legislate domestic laws. They are less likely to collaborate with other states with proper processes for discovery in a joint criminal investigation. They are less likely to improve their own data security, so states would have confidence in interacting with them. These types of obligations are firstly required by the treaties themselves and additional protocols, but also something that a state would logically do if it wanted to over-rely on that treaty more. At no point throughout the affirmative team's case did we hear an explanation as to how international cyber treaties prevent private companies or domestic governments from going about their business to solving cybercrime. Throughout our case, we explained why international cyber treaties create an incentive on these states and private actors to innovate, and therefore, even on their own metric of this debate, we have explained why ICAULT is stronger. Importantly, we've clearly established the harms that would happen if countries did not over-rely on cyber treaties. With less reliance, the Emotet, the most destructive malware in the past decade, would never have been taken down, and the immense threats that we face today would not be solved. Thank you.
Thank you very much. We have now heard the statements from both teams for the debate. You can relax. You will no longer be graded after this part. I would just like to say on the side of organizing team, congratulations to both teams. You are now first-time participants from your institutions for the competition. Well done for the participation in the group phase. And without much ado, I want to pass the floor to our student organizer, Ms. De Paula, who will be the host for your final part of this session.
Hi, good morning. Congrats to both of you. I'm gonna start by the University of Monash to ask Mr. Low, how did you find the match?
I found the match quite exciting. I think I can see that our opponents are quite well prepared and are great debaters. They do sound quite practiced in the sort of parliamentary debating that we typically do. Yeah, it was quite exciting.
I'm glad. Miss Tilo, do you have any feedbacks about the match?
Firstly, I'd like to thank the students from the University of Monash for the very engaging and interesting debate that we had today. And yeah, it was a breath of fresh air to have such an interactive debate and to learn so much from them as well.
Thank you. Same question for Mr. Tan.
Thank you, and thank you everyone for the debate. I really enjoyed this debate. I think that there was quite a lot of interaction between the two sides, which I really enjoyed.
Thank you. And Miss Setilo, John, do you have any feedbacks? How did you find the match?
I thought the match was very it was fun. There was a lot of clash and interaction, and I enjoyed the research behind preparing for this match.
Perfect, thank you very much. Now I'm gonna ask you both of the teams about the group phase. Is there something that stood out? I'm gonna start from the University from Monash, from Mr. Law.
Sorry, could you repeat the question?
Of course. During the group phase, is there something that stood out?
Well,
How
I
did you
think what
find the
stood out,
group phase?
I mean, I thought it was quite enriching. I think there's a lot of space for discussion that isn't necessarily present in the classroom. So a lot of the more controversial aspects of international law that are not really being discussed, I think those gray areas are basically something that we get to research a lot on and speak on and explore as a result of the group phase, because the group phases topics were all pretty good.
Perfect, thank you very much. Same for you, Ms. Tilo. Is there something you want to say about it?
About the group setup, right? Yeah, like Joel had said, that it is something that we don't really find in the classroom. So to have it here, it's quite, like I said earlier, like a refreshing experience as well. It exposes us to like a new side of things, and we get to learn and exchange quite a lot. So it was very enriching.
If I can, just a curiosity question from the organizing team, as it's your first time participation for the competition for both sides, were you also taking a look at the other teams from the other groups? Did you have a debate perhaps that stood out to you as well, and that might not have been the one that you participate in directly? Perhaps passing to Monash University, because I saw Mr. Law nodding already.
Well, I watched another debate because, well, my friend was in it. I can't remember what the topic specifically was, but can't remember anymore. But I mean, either way, the topics were quite interesting as well.
Right. Thank you. And the same question then for the Botswana team. Did you have the chance to look at the debates of other teams? Is there perhaps one or a team in particular that stood out? Whichever one of you wants to answer, Ms. Jonde or Mr. Tila.
I think for me, it was like the debates with the University of Antioquia, because like I got to learn that debating style, how they incorporate legal authorities and analysis into it. So that was something that was new to me and insightful. So like most of the debates are the ones that I was paying particular attention to.
Oh, that's quite exciting. And I can say from the experience over the years and also in this group phase actually too, the progress in the debate style and the presentation of the teams, it's quite an interesting to see how you start on the first debate and where you are on the last debate of the group phase. So really head down to both teams. And perhaps a traditional question for a twist at the end before we conclude the session would be Ms. Njonde or Mr. Tila, if the Monash University team messaged you on LinkedIn that in a week they would be visiting your country, what would you say would be the first thing you recommend them to see or to experience?
May you please repeat the question?
If the other team messaged you that in a week they would be visiting your country, what would you say the first thing they should experience or definitely see should be?
The National Museum of Botswana, or they should go and the national parks. They should go see the game reserves. Yes, and animals.
Right, so culture and environment in one swoop. What about Monash University students? What would you say if the Botswana team messaged you that in a week they would be visiting? What should be the first thing they should see or experience?
Well, I feel like we've got some nature lovers in the chat. So I really like nature, and I really love the Northern Territory. There's a lot of animals out there, beautiful waterfalls. A lot of the animals are a bit dangerous, but I'm sure it's the same in Botswana as well. Just different types of predators out there. And then I guess aside from like nature, I'd say Melbourne and Sydney are pretty iconic places.
Yeah, like the Great Ocean Road's a pretty good one in it's Melbourne's in the state of Victoria, and Victoria's biggest landscape attraction I think is the
Great Ocean Road.
Yeah, the Great Ocean Road. If you go to Sydney, you would do probably the Blue Mountains. Yeah.
The Great Ocean Road's very picturesque. It's got lots of little towns you can stop off along the way. Rainforests you can explore as well. These big redwood tree gums that are really cool, really tall. Yeah.
Well, I think that could be quite a worthwhile experience for both teams if you have the opportunity to visit a country of your opponents. On the side of organizing team, I do encourage you guys to stay in touch. It is always good to have a connections, especially when you will be entering your career. If you want to run or if you have questions about the legal system of the other country, or if you just want to perhaps, if you end up on the international level, so you would be working in international organizations. We will, of course, have a networking event in April, which will be after the Met Edition ceremony, where you will find out which teams will proceed into the next phase of the competition. And finally, of course, we thank the 3 judges that will review your match and will provide the scorecards. And once more, congratulations to both teams. Well done.
Thank
you so much.
Sorry, can I just check when will we know the dates, and also like if we proceed, like when do we know if we proceed or not?
Right, within a week, we'll send an email to all participants with the specification of the dates, but you can expect it to be after the Easter break in Europe. So the Eastern period is break scheduled for the competition for everyone to take a breath, because so far you have had announcement of the topic, then within a week you had a match, and then again. So this will be a time to take a break. It's quite an intense schedule for the rounds. So just relax, and we'll provide you this course once as soon as we can confirm the data from the judges.
And sorry, how many teams break through to the next round?
All right.
Yeah.
Yes. Yes.
Yes, so just to tell, so there are 8 groups, and for the 8th of finals, it will be the 2 best teams of each group. So for your group, it will be 2 teams out of 4. It means 2 teams out of Monash, Antioquia, Botswana, and King's College. So, so currently, obviously, we are waiting for the last match of your group. The last match of your group will be between Antioquia and King's College next week on Monday. And yes, of course, after that, once we get the results from your match, results from the other match, we'll know which are the 2 best teams. The 2 best teams for the group A will be meeting the 2 best teams of the group B. So it means the best team of your group A will meet the second team of the group B. And this we'll know, of course, as soon as we know as well the result of the group B. So so we don't know yet which teams as well from the group B will be I mean, which team will be first and which team will be second. So yes, the best team of your group A will meet the second team of the group B, and the best team from group B will meet the second team from group A. So that's what we can tell for the moment.
Beautiful. Thank you so much.
Thank you as well. Wishing you both a good day.
Have a great day, evening as well. Bye-bye.
Thank you.
Thank
Bye-bye.
you. Bye. See everyone.